Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Naim Nabil, and today I will be presenting on the case of Malayan Banking Berhad and Premier Expense Sdn Berhad and others, the owners of and or any other persons interested in the ship of vessels, the Zuhairi and Nasuha. So first of all, before I go on to the case summary, this case has one plaintiff and seven defendants. There are a lot of defendants, so I will try to make it as understandable as I can. So moving on uh, to the summary of the case. So the plaintiff granted loan to part finance to two vessels, Zuhairi and Nasuha, to the second defendant on the request of the first defendant. To part finance here means to aid or to help or to give money to the second defendant so that the second defendant could buy the two vessels. So as security of the loan, the two vessels were to be mortgaged by way of a third party mortgage in favor of the plaintiff. It was later found out that the mortgage had never been registered in their favor. Instead, the mortgage was registered in favor of the third defendant. The plaintiff filed this action and obtained order to arrest the vessels. In an interview, the fourth defendant claimed that the vessels were owned by their party. However, the fourth defendant here in this case is not a significant party to the case. It is just for the purpose of the story, the fourth defendant came into uh, the action. After the arrest, the fifth defendant intervened and claimed that the vessels were transferred to them by the third defendant. Plaintiff claimed for this action and the court granted an injunction over the vessels. However, despite the injunction, the fifth defendant sold and transferred the ownership to the sixth defendant, who was aided by a loan from the seventh defendant. Okay, now we go to the issues and decisions. There are actually 5 issues in this case, but the one that is concerning frustration is this issue, which is what is the effect of a transaction affected in breach of a court order? So a court order in this case is the injunction. So the decision of the court was that the plaintiff's contention that the transfer from the fifth defendant to the sixth defendant was defeated by the doctrine of frustration was untenable. In other words, it was to say that the contract was not frustrated. Okay, now we go to the arguments uh, from the plaintiff and the defendant. We look at the arguments from the plaintiff. So the plaintiff argued that the transfer of ownership from the third defendant to the fifth defendant was void. Why? This is due to the fact that the fifth defendant, who had in fact an injunction order when they subsequently transferred ownership of the vessels to the sixth defendant. And although the sixth defendant were bona fide purchases for value without notice and had their rights registered, the transfer of ownership from the fifth defendant to the sixth defendant was void as it was in breach of injunction. So basically, the overall argument that the plaintiff is trying to claim is that the transfer of ownership done by fifth defendant was void due to the fact that the court granted an injunction over the vessels. Now we look at the arguments from the sixth defendant. The sixth defendant purchased the vessels pursuant to a bills of sale dated 15 August 2005 for Zuhairi and 8 February 2007 for Nasuha from the fifth defendant. And the sixth defendant submits that they are bona fide purchases for value of the vessels and they had no notice of any injunction. And the sixth defendant had paid the consideration in full to the fifth defendant, which is financed by the seventh defendant. So what the sixth defendant is trying to say that they had fulfilled all of their responsibilities in order to attain the two vessels. So by right, the two vessels should be no problem for them to owe. So now we move on to the case analysis. So what is the significance of this case to our topic? So this case is concerning the doctrine of frustration. What does it mean by frustration? Frustration is when after a contract has been formatted, a change of circumstances or condition renders both of the parties to be in an impossible state to legally perform the contract. Section 57 Clause 2 of the Contracts Act 1950 has provided with the definition of frustration. However, the section does not explain thoroughly on what does it mean when a contract becomes impossible. A frustrated contract will also render it to be void. In the case of Guan Aikmore KL Sdn Bhd and Selangor Properties Limited, Gopal Sriram GCA has laid down three elements to establish the doctrine of frustration. The first is no provisions has been made when such change of circumstances occur. Second, none of the parties are responsible for the change of event. And last, the event has rendered the contract radically different from the original contract that both of the parties has agreed upon. Sorry. Okay. So, as we all know, there are a few instances where the doctrine of frustration will instantly be established. For example, we have statutory prohibition, we have the outbreak of war, the inability of promisor to obtain license, and many more. And one of them is grant of an injunction. So, when the court orders an injunction, it renders both of the parties impossible to perform in accordance to their agreement. So I take the case of Standard Chartered Bank and Kuala Lumpur Landmark Sdn Berhad to illustrate on how the grant of an injunction actually works. So basically, in this case, the plaintiff, the plaintiff granted a loan, a total of 20 million ringgit to a third party, and the defendants secured the repayment of the loan by charging certain of its lands to the plaintiffs. However, when the third party failed to repay the loan, uh, the plaintiff, of course, will commence legal proceedings and applied for an order for sale of the charged lands so that they could satisfy the debt. The parties entered into a redemption agreement. A redemption agreement is basically the defendant is supposed to do some kind of actions so that in return the plaintiff will not the plaintiff will suspend the legal proceedings. So the redemption agreement that the both parties agreed to is that the defendant will pay 2 million ringgit and then will pay the rest, which is 18 million ringgit at a later time. However, on the 1st December 1989, Monsia Investment Private Limited served the plaintiffs and defendants with an injunction, meaning that both of the parties has been granted with an injunction. Therefore, the defendant could not pay the rest of the debt, which is 18 million ringgit, to the plaintiff. So, because of this, the plaintiff, uh, the plaintiff pursued their claim against the defendants so for so that they could take possession of the charged lands. So this matter was brought to the High Court, and the High Court allowed the plaintiff's application, and it was held that the injunction was actually frustrated the redemption agreement. However, this case was brought to an appeal. Uh, in the appeal case, the defendant, now, which is the plaintiff before, the defendant is Standard Chartered Bank. They argued that due to the delay of the payment, uh, it would the bank would not obtain the whole benefit from the agreement. But the court did not agree with the argument brought by Standard Chartered Bank. They said that the defendant would suffer no detriment or loss of benefit or any prejudice by the delay occasioned by the injunction in the performance of the redemption agreement. So, in the appeal case, the decision was reversed, meaning that there was no frustration or of the contract. Okay. Uh, Now, based on the prior facts, I agree with the decision of the court in the current case, which is that the transfer of vessels from the fifth defendant to the sixth defendant was not frustrated. Referring to the case of Standard Chartered Bank, even though the summary of the case is different, but both cases actually share the common ground on the storyline where both of the parties were granted with an injunction over the subject matter. Uh, in applying the doctrine of frustration, the supervening event is no need to be unforeseen or unexpected. Okay. Uh, However, in the current case, it was never regarded as a supervening event in the first place, because the injunction was granted prior to the transfer of vessels from the fifth defendant to the sixth defendant. Had the injunction was obtained after the transfer, then the contract had been frustrated. Meaning here is uh, the fifth defendant actually transferred the ownership of the vessel to the sixth defendant uh, after uh, uh, I mean, okay, sorry. So the injunction was granted before the transfer of vessels from the fifth defendant to the sixth defendant. Uh, so if the injunction was granted after the transfer, then the contract would have been frustrated. And also, the sixth defendant had no knowledge over the injunction, and the claim that they are bona fide purchases of the vessels are indeed relevant, because it relates back to the second point, which is the transfer happened after the grant of an injunction. So the sixth defendant is the transfer of ownership between the fifth defendant and sixth defendant is nothing to do and has no relation with the grant of an injunction before. So therefore, the transfer of ownership is not void, and the six defendants are actually the bona fide purchasers of the vessels. So, in conclusion, based on the two cases, we can see that a grant of an injunction does affect the contract to be void, but it also depends on the circumstances. So that is all for me. Thank you for listening. Assalamualaikum warahmatullahi wabarakatuh.